Hello, my name is Lily and I am a senior immigration attorney at Neighbors Link Community Law Practice. I'm here to discuss a brief introduction with you about immigration court and what you need to know. The first document associated with immigration court is the notice to appear. That's DHS form 1862. This document contains important information about your case, including the location, date, and time of your court hearing. It also has the allegations upon which the government believes you're removable from the United States. You can see here, highlighted in yellow, first, 4 allegations made against you that the government believes establishes your removability from the United States. Below, also highlighted, is the location of the court, a date, and time. At a court hearing, the judge will require that you respond to these allegations before your case will proceed. If you admit the allegations, the court will likely find you removable from the United States. But fear not, if you're eligible for relief, you could provide a defense to your removability. There are 3 courts or immigration courts in New York City. One at 290 Broadway, another at 26 Federal Plaza. These 2 courts are across the street from each other, so very close in proximity. And the third is at 201 Barrett Street, where there's both detained and non-detained dockets. There are 2 types of hearings before the immigration court. The first is the master calendar hearing. This is a hearing where the judge gets updates and figures out the status of your case. During these hearings, you can ask for an adjournment to find an attorney if you do not yet have representation. It is also during master calendar hearings that you respond to the allegations in the notice to appear I just discussed. These are different from the individual hearing. The individual hearing is the trial before which you will submit all of the evidence of your case, including country conditions, any supporting evidence, police reports, medical documents, anything like that. And then at your individual hearing, that's when you will testify before the court and be cross-examined by the Department of Homeland Security attorney. You should be provided with an interpreter if you do not speak English so that you can understand what's going on in the case. Here are some common defenses to removal proceedings: asylum, special immigrant juvenile status, adjustment of status, meaning obtaining a green card, a U visa if you've been the victim of a certain type of crime in the United States, cancellation of removal, or voluntary departure. If the judge does not grant your case, you can appeal if you disagree, but that must be done so within 30 days of the judge's decision. It is very important that you attend all scheduled court appearances. You should receive a hearing notice with the date, time, and location of your hearing. You should have your first hearing notice or your first scheduled master calendar hearing. That should appear on your notice to appear, as we discussed. But subsequent master calendar hearings will come with a new hearing notice with a new date, time, and location. If you do not go to immigration court when scheduled, the court can order you deported in your absence. And that means you may become a priority for ICE enforcement, including arrest and detention. If you miss your court appearance and are ordered removed, it is possible to reopen your case, but generally you must do so within 180 days of the hearing you missed. Another way to check your court date is to call the EOIR hotline. The number is provided here. If you're a Spanish speaker, you can press 2 for the automated message to be in Spanish. You will then enter your A number, which is on all of your immigration court paperwork. You can confirm your name by pressing 1 and press 1 again to hear your next court date. We'll also provide you with the location and the name of the judge who's presiding over your case. Another thing that's very important to keep in mind is that you must provide the court and also the Department of Homeland Security with a change of address form if you move. You're required to do so within 5 days. This is Form EOIR 33. Contains your old address as well as your new address, your signature and the date, as well as a proof of service to demonstrate that you also filed the form with the Department of Homeland Security. You must mail this form to the Immigration Court and to the Department of Homeland Security, as well as keeping a copy for yourself. This is extremely important because if you get any important information or correspondence from the court and you have moved, you will not receive it unless you provide the court with this form. If you move out of state, this will require a motion. To move your court hearing from one state to another, you must file a change of venue motion with your change of address form. If you do not file a change of venue motion, you will be required to go to your court date, no matter how far away it is. These motions must include the date and time of your next scheduled hearing, admission or denial of allegations in the notice to appear, a list of application and forms of relief for which you plan to apply, your new address and telephone number if applicable, and an explanation in detail why you want to change the location of your court. You should also provide any available documents to prove that you have moved. This will be, of course, and the EOIR 33 will also be included in this motion. Another important factor to keep in mind is ICE check-ins. ICE is not part of the immigration court. It's a separate government agency. This agency is responsible for the arrest, detention, and removal or deportation of non-citizens. It is also this agency that argues before the court the reasons why they believe you are removable. ICE may want to keep track of you as part of the conditions of release if you were detained. It's very important you go to all ICE check-ins. ICE is located on the 9th floor of 26 Federal Plaza, where one of the immigration courts is also housed. Be sure to bring your hearing notice with you and an order of supervision if you were provided with one. Who can give legal advice? This is also important to keep in mind because only accredited representatives at a recognized nonprofit organization, religious or social service organization, or a licensed attorney can provide legal advice. Notary public or notarios are not attorneys and cannot give legal advice. You should never be charged to obtain the forms. The immigration forms are all available for free online to be downloaded. Never sign something with false statements or inaccurate statements. This can have very serious effects on your ability to apply for any benefit in the future. You can check whether someone is an attorney or a licensed attorney by using the link below. Remember to protect yourself. Keep records. Know your immigration attorney's name and contact information. Keep a copy of the retainer you signed so that you know what they're responsible for. Keep receipts of all your payments and copies of all the applications submitted. Thank you so much for listening. I wish you all the best with all of your future hearings and relief.